All right. This is the time set for a contested hearing regarding an injunction against harassment in CV 2026-002-304 in the matter of Laura Owens versus Robert, is it Andrejev?
Case sounds like a Y. That helps. Andrejev.
Okay, that's Andrejev.
Yes.
Okay. All right. Let's start with plaintiff's counsel.
Good morning, Your Honor. David Gingras on behalf of plaintiff Laura Owens. And to give you a little phonetic help with my last name, it's pronounced gin like you drink and grass like you mow. Gingras.
All right. Gingras. Okay. All right. And counsel for defense?
Good morning, Your Honor. Matthew Kelly for defendant Robert Andrejev.
All right. All right. Anything, any preliminary issues that we need to discuss before we get started?
None from our side, Your Honor.
Okay. And we're set for an hour today. You all are prepared to make your cases within that time frame?
I am.
Yes.
Okay. All right. And you've exchanged your exhibits and your witness lists?
Yes.
Yes.
Okay. The people in the gallery, any of them going to be testifying?
Not from our side.
No.
Okay. All right. So anybody who will be testifying would be limited to the defendant and the plaintiff?
That's correct.
Okay. All right. So let's start off by having the two of you stand and raise your right hands to be sworn.
You are about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
I do. All right. Thank you. And you can make yourselves comfortable. All right. So both sides will have approximately half an hour. That will include any time that you spend doing your cross-examination, anything like that. So keep that in mind. And do you want to make an opening statement? You don't have to. It's up to you.
Given the short time, I think I'll wrap it up at the end.
Okay. Okay. How about from defense? Okay. All right. Then whenever you're ready to call your first witness.
Your Honor, would you like her to be on the witness stand, or?
It's probably easier once we get to the time of cross-examination. It's a little strange when you can't see who you're talking to. So why don't you come on up to the witness stand, if you would, ma'am?
Yeah.
Just head up the ramp over there. There you go. And watch out. I hear there's a little area where people trip sometimes. You didn't have any trouble, but just in case. Yeah, the chair will move. It's a little difficult because it's on carpet.
Okay.
All right. Okay.
I mean,
Yeah. Take your time. Just get
get
it situated.
Okay. Perfect.
There you are. And whenever you're ready.
Okay. Thank you. Hi. What's your name?
Laura Owens.
Laura, did you file the petition in this matter on January 20th, 2026?
Yes, I did.
Okay. Exhibit A, if we can have that. Am I pulling them up, or are you?
We have it marked, but you'll have to play it off of your own computer. Do you happen to have another copy of it on your?
I do. It's right. If you want to just turn it on, it'll be there.
Plug in your laptop, you'll be able to play it.
Yeah, it's plugged in. Okay. All right. So Laura, you filed the petition on January 20th, 2026. At the time that you filed this document, did you believe that everything in it was accurate?
Yes.
And since you filed this document, did you learn that there were some mistakes that you wanted to correct?
Yes.
Okay. If we look at Exhibit B real quick here.
So our exhibits are not numbered as letters. They are numbers. Did you receive an exhibit list?
I did.
So
I see what you're saying. Yes.
Yeah. I Drew, the clerk, kindly tried to identify.
That's perfect.
How you had them marked, but if you all are used to appearing in civil court in front of judges, there is a different case management process that they use. The commissioners, for some reason, don't. And so we have this issue with respect to our exhibits sometimes. So it's not you all. That's just how it is. But Drew kindly tried to mark it so that you guys can just make sure you're referring to them the way we have them marked. Otherwise, it won't make sense in the record.
I like Drew's list. I made my own, but he's got the numbers. I'll use his numbers. So,
okay.
So we were talking about the petition was Exhibit 1.
Was there anything? Did you have anything?
I'm about to object to Exhibit B.
Oh, okay. Well, there's no Exhibit B, but
right.
Yes. Okay.
Exhibit 2.
Okay.
And Your Honor, can I just show her the paper? It's a bit easier than doing it on the screen.
Exhibit 2?
This is Exhibit 2.
Okay. Okay. And did you want to respond?
No, Your Honor, I haven't moved to admit it yet. So I'm just showing her this document.
Okay.
And then I'm going to ask some follow-up questions. And I guess if there's an objection, we can talk about that one and if it happens. But
Okay. Are you objecting to her reviewing it or testifying about it?
Yes, Your Honor. If she wants to testify, she can testify. She doesn't need a document to read off of.
Do you want to be heard?
again, I'm not moving to admit it at this point. I'm just asking her to look at it. I don't see an issue with that. But in any event,
So why don't you ask her questions, and then if she doesn't know the answer or needs to refer to so this is a document that she prepared. So if she needs that to refer to, we'll cross that bridge when we get to it.
Sure.
Okay.
Makes sense.
Okay.
Okay, Laura, forget about Exhibit 2 for a second. After you filed the petition in this matter, did you realize that you made some errors or typos or mistakes that you wanted to correct?
Yes, I did.
Can you generally tell the court what those mistakes were?
Yes, absolutely. So the only errors I made were that I mislabeled some of the numbers of the videos, but all of the quotes appeared in his videos, in transcripts and in the videos. The numbers were wrong.
Okay, so since you filed the petition in January, have you learned that anything that you accused the defendant of saying was not said by him?
No, everything was said by him.
Okay, Laura, Arizona.
Let me ask. Are you as part of this asking to amend the petition?
Well, the petition always, I think, would be amended to conform to the evidence. So at this point, she's not changing anything. She's just saying that there were some errors in terms of number of what the video title was, I think.
So I think if you're asking to amend to conform to the evidence, I guess, so from the defense perspective, let me just make sure, are you asking for additional time, or is this something that's a surprise? Do you need a continuance?
Your Honor, if they are going to amend the petition, I believe that they should do so now, so that we know what petition we are discussing. As Your Honor knows, the rules require that evidence be limited to
The petition, right. Okay, so do you want a form to amend?
Not at this time. She's not. All we're trying to do is there was a dispute that arose after the petition was filed. There was a motion to quash that was filed that argued that Ms. Owens had fabricated certain statements and so forth. I'm just trying to get her to respond to that and explain for the court that what we have was basically a typo.
Okay.
Your Honor, counsel is misrepresenting what we said in our motion, and what happened is plaintiff attributed certain statements to a certain video. They are not in that video, and therefore, because they are not properly in the petition, we believe that unless the petition is amended, they are not at issue here.
Okay. So do you want to just fill out the form? It's just a form.
Yeah, I can do that, Your Honor, but I prefer to not eat into my time with this issue.
No, I understand that. But why don't let me give you the form, and then when you have a moment, you can take a look at it. It doesn't look like it'll take a real long time. All right.
Well,
go ahead.
In any event, Your Honor, the petition alleges that the defendant made certain statements, and Ms. Owens is simply confirming that she believes that he did. And we're about to show you what those are.
Okay.
Okay. All right. Laura, Arizona law defines harassment as conduct that is directed at a specific person and that would cause a reasonable person to be seriously alarmed, annoyed, humiliated, or mentally distressed, and the conduct, in fact, causes that effect. Within the last 12 months, has a defendant done anything that you felt was harassing by that definition?
Yes.
Okay, can we look at I called it Exhibit D, and it's probably going to be Exhibit 4 then. Again, am I playing it or is it clerk?
You are.
Okay, so let's see. Okay. Laura, do you recognize what's on the screen there?
Yes.
See if I can make that bigger. Can you tell the court what this is, Exhibit 4?
This exhibit is one of the videos that he made about me.
And is this, let me just clarify, is this I'm following that you're, so in the petition, there are allegations about videos that are, or I don't know if they're videos or podcasts or something like that are numbered. And so what you're playing is a different number than what's in the petition, or this one aligns?
I'm not sure, Your Honor. We'd have to ask the witness.
Your Honor, this particular screenshot is of a video that is not at issue in the petition, and we object to discussing it because it's not relevant to the petition.
Again, Your Honor, if we have to amend the petition to include these things, I'd like to do that.
Yeah. So why don't you go ahead and just fill out the, in brief, just amend.
Yeah, okay.
And then the issue then for defense is you have three options. You can have a continuance within the timeframes provided by Rule 38 of the Rules of Protective Order Procedure. You can have a brief recess so that you can review the amended petition, or you can waive those things and proceed. Okay. So once you
Sure.
just put in then you're substituting something for something, right? A number.
Amending to add.
Yes. Okay.
Yeah. So this is going. You want me to write the exhibit number as well?
Well, whatever you need to do to just make it clear for the written record.
Okay. We've got that. Okay. You want me to do this now as we go along, and then we'll keep adding to it if there's any further objections?
To it, but let's do what you're asking for right now.
Sure. Okay.
So you want to so have her sign, and so of course read through it and make sure that it's accurate.
It deals with this one thing.
Okay.
Does it deal with this as well? I think it deals with this as well.
Well, you might as well add that as well.
Yes.
Then add
Okay.
those. In fact, yeah, take a minute and just add anything you need to.
Oh, okay. Okay.
I believe everything else.
Okay. This.
Yeah. Just the exhibit number.
Just to add that.
Yeah.
And again, for my understanding, it sounds to me, and if I understand correctly here, that the allegations in the petition are not changing, but it's the identification of the particular video or whatever we're talking about, right?
Correct.
There's one correction to a video number.
Right.
She put what 272? What was the error? 272 and it's
Yes.
273.
Okay, so it's the allegation, the substance of it
Does not change.
doesn't change. It's just the identification
This is
of
an
the
addition.
video.
This is an addition.
Oh, okay.
This is the only addition, I believe, Your Honor. So, right.
Well, and the thing after he was served.
This.
That.
The post order interview.
Yeah.
Okay. Is that okay, or do maybe I should put the
Just a little bit of description about it, whatever date and yeah. We okay for time if we need just a little bit longer?
Sure.
Okay. I can talk really fast, but I prefer not to.
Well, I am told that I can as well, but I will try not to.
Slowing myself down a little. These are only things that you didn't list in the petition that you want to bring up now. So it's just anything new.
Okay. What about that?
No, it's not so.
Okay. Oh, I didn't sign it. Oops. Oh, and the approximate date of that was 225, I believe. Or not 225. That wouldn't make sense.
But it's
25.
25.
Okay.
Does the clerk need to?
Well, we do need a copy of it to make it part of the record. So why don't we, Maurice, would you be able to make a copy of it real quick? And then just so we can also give a copy to defense counsel. You all are doing more than the average bear regarding this proceeding. And so I'm trying to make sure I'm following the rules because I don't normally we don't usually get this far into the weeds. People don't usually, I say into the weeds, but I mean, people don't usually file written requests in advance and things like that because of the very tight timeframes. I'm sure you all realize why people often don't do that because it's tough to get it done that quickly. So the rules do seem to indicate that it needs to be done at the time it's happening. So that's why I'm trying to do it this way. I realize it's a little disruptive to our proceeding here, but trying to make sure that we're following the rules of procedure as written.
We love rules of procedure.
Right? You guys are attorneys, so you know about this rule thing. You can get, yeah, that'd be great. I have a copy for everyone. Thank you. All right. Do you want to take a brief recess?
Yes, Your Honor.
Okay. So we'll just take a brief recess so that they can just take a look at the proposed amendment, and then we'll maybe 5 minutes. Is that okay? Okay. We'll take about 5 minutes. Let them have a look, talk to each other, and then we will restart. Okay. I think as long as it's just 5 minutes, you're welcome to go sit back down, but you're also welcome to just stay there. Either way, just
Okay.
we'll all just hit pause.
Laura, do you need water?
I
I don't see any jug or anything.
think I'm okay. I just have one question for you about
The mic's going to stay on, so you might want to not. Sit
Yeah, the microphones are always on in here.
Oh, that is
It's good to. Yeah.
okay,
This
so
is
you're
just a
just asking me
screenshot,
to
and then
know.
there's a video.
You're just asking me.
I'm doing what's called laying foundation. This is the whole point.
Yeah, I think some of it is meant for, when we're not all here together, but. All right, so are you all ready to get started again?
Yes.
Yes? Okay. So we're gonna go back on the record in CV 2026-002-304. And any motion that you're making, or are you prepared to proceed? What I meant by motion is, did you need a continuance or you want to proceed today?
We'd like to proceed today, Your Honor.
Okay. All right. Go ahead then.
Okay, thank you, Your Honor. Laura, before the break, I'll just step back a little bit. I was asking you, I read the statutory definition of harassment as what that statute says, and then I asked you within the last 12 months if you had seen anything or had any events occur that you felt the defendant was harassing you. Do you remember that?
Yes.
Okay, and in the last 12 months, has the defendant done anything that made you feel harassed?
Yes.
Okay, and looking at my exhibit D, which is plaintiff's exhibit 4, did you recognize this?
Yes.
Okay, can you tell the court what this is?
This is a video that was made on July 18th by the defendant.
Okay, what the title of it, I think it says 0209, do you see that?
Yes.
And it has your name, Laura Michelle Owens, that's your full name?
Yes.
Okay, this is a screenshot, but did you actually watch this video?
I read the transcript and saw part of it. Yes.
Okay, let's go ahead and play this.
And let me just verify. So you said July 18th, and obviously we haven't hit that in 2026. So are you talking about 2025?
Yes.
Okay.
I'm sorry about that.
That's
yes.
okay.
Okay, so Laura, I'm going to play for you our exhibit E, which should be plaintiff's exhibit 5. I'm going to ask you some questions about this.
To trial by jury. Laura Owens was an aspiring influencer who now finds herself in the spotlight after her paternity claim involving a former Bachelor contestant spirals into a legal nightmare. Laura, portrayed as charismatic and charming, manipulating her social media platforms to gain sympathy and followers, while maneuvering her way through the legal system and using it as a weapon against her victims. She is traveling down a path that there may be no turning back.
Laura, that video that I just played for you So you said that you've seen that before?
Yes,
And that where did you see it?
on YouTube.
Was it on the defendant's YouTube channel?
Yes.
Okay. Do you have any knowledge of if he created that himself?
I believe he created it himself. It was
Okay.
Yeah, it was on his channel.
Did that video cause you any alarm, annoyance, humiliation, or distress?
Yes, all of the above.
Okay. Within the last 12 months, has the defendant done anything else to harass you?
Yes.
Okay. Let's take a look at I think our exhibit F. Well, let's leave that out for, well, exhibit F is a picture. So Your Honor, let me if I can just ask some foundational questions and then maybe we can get a ruling on that. Laura,
I'll let you ask foundational questions.
Laura, do you recognize this exhibit, which is, again, it's our exhibit, I believe it's F, and it's plaintiffs must be 6.
Yes, I recognize this.
What is that?
This is my home it's a casita on my parents' property where I live.
So it's a picture of your house where you live?
Yes.
And where was that posted?
On Discord, I believe.
Okay. And that date, it looks like it was posted in October of 2024. Do you know if that picture is still up somewhere?
I do not know if it is.
All right. That's outside of the year. So you're not alleging that's part of the harassment in this case, right?
No.
But it's something that the defendant did in 2024, posting a picture of your home that frightened you.
Yes.
Okay. Let's look at Exhibit G.
Your Honor,
Go ahead.
that you disregard this exhibit. It has not been authenticated, and it is not under Rules 1001, 1002, a proper copy of the exhibit.
Your Honor, I'm not moving to admit that one yet. So you heard what you heard about it, and you can do whatever you want. Give it as much or as little weight as you want.
Okay. So in terms of my consideration of the exhibit, I think what I've heard in testimony, and certainly could be rebutted in your questions, but what I heard is that the person who lived there said, this is a photo of where I live. So I don't know that authentication is necessarily an issue. Go ahead.
Your Honor, authentication that particular photo was posted on my client's.
Authentication of where it was posted.
Precisely.
I see. I thought you meant of the photo itself. Okay. Okay.
The entire exhibit.
Okay.
Which indicates.
I see. So she says he posted it on Discord, and so
we ask Your Honor to disregard that because their foundation of that hasn't been laid. It hasn't been on.
Okay. So did you want to be heard on that issue?
Yes, Your Honor. Again, I'm not moving to admit that yet, and I can deal with this really easy with a single question.
Okay. All right.
Ms.
Go ahead and
Owens,
ask your question.
Do you know, regardless of when it happened, do you know if the defendant has ever posted a picture of your home on social media?
Yes, he has, and a simple search of Discord would show he did post that.
Okay, and you became aware that he posted a picture of your home on social media?
Yes.
Okay, let's move on then. Looking at the exhibit in front of you is our Exhibit G, and I'm struggling to see because I'm sorry that Drew, was it Drew? Your list doesn't have the same titles that I do. In any event, do you recognize Exhibit G? I believe this is going to be Plaintiff's Exhibit 7.
Yes.
Can you tell us what that is?
It's something posted on the defendant's YouTube channel, and it has a quote and my face on it many, many times.
Let me stop you a second. So the defendant has a YouTube channel. Can you point out in this picture what tells you that we're looking at his channel?
It says, "Hey Rob" as the username, and not the defendant's username.
And how do you know that?
Because I believe it says Robert Andre at the bottom.
Well, you've looked I assume the court is familiar with how YouTube works, but if you click that button that says, "Hey Rob," and then you're taken to his channel, are there videos of the defendant on that channel?
Yes.
And did that cause you to think that that's his channel?
Yes.
Okay. I don't think it's a disputed fact, so we'll move on. But also looking at this screenshot real quick, can you see where it says, there's not a publication date, but it appears to say at the bottom, streamed 3 weeks ago. Do you see that?
Yes.
Did you see this at some point in the last year?
Oh yeah, it was
Okay.
recent.
And the green text in quote, can you read that for us?
When darkness falls over the city, predators take to the skies. Laura Owens transforms into multiple terrifying hybrids with human heads, bat-like bodies, and leathery wings, hunting unsuspecting victims from above. As shadows stretch and screams echo through the night, the line between nightmare and reality blurs, and no one is safe from the winged horror lurking overhead. And it says, "Leave us alone now," or...
Laura, did this, whatever you want to call it, I mean, it's a screenshot of a thing, but when you saw this, did this cause you any alarm, humiliation, or distress?
Yes.
Okay. Moving on to our Exhibit H. This is going to be Plaintiff's Exhibit 8. Let's play this here.
Thing writes, recall up all the horse shows in California this weekend and pretend to be low and say you want to confirm your attendance at the competition. That way we can find out where she will be. That's a fair way to do it, right? And we all know the names, and you're not causing any trouble. You're not influencing anything. You're not talking bad. You're just using your First Amendment rights to find out some information that's public knowledge anyway. It's a competition. And let's say we are fans of her equestrian abilities. I want to know which one she's in. I want to go see, right? Let me make another comment for you, too. A lot of these competitions, there's usually a side business going on where you can request videotapes and pay money from a professional, right? So keep that in mind. If anybody does go, you can also ask that service, pay the money, and then let me know, right? And then you can get the video professionally done of her riding on the dates you want, every date, all shows, one show, whatever.
So, Laura, there's this funny little rule of evidence called authentication. And what that means is that for the court to consider evidence, there has to be some evidence to show that this thing, what it is, where it came from. So can you explain, first of all, what that video is? Where did it come from? Is this something that you created?
No, it's not something I created. It's something the defendant created.
Well, it looks like it's actually a screen recording of a phone. Is that what it is?
Yeah.
But, okay, this video is something that you saw. When did you see it?
I saw it a month ago.
And do you believe that was about when he posted it?
Yes.
Okay. And in this video, we could replay it, but I don't want to. He starts out with a comment about calling up horse shows, and the transcript says LO, which I guess is your initial.
Laura Owens, yes.
And he talks about calling up horse shows and pretending to be you to see if you're in a particular show. Can you sort of explain to the court why that's a concern for you?
Yes.
Or is it a concern for you?
Yes, it is a concern for me for several reasons. So this had been part of a motion to allow travel. As you guys are all aware, I have a criminal case pending and I have to file a motion for travel. And I was going to help my sister with childcare in San Diego, and the defendant did not believe that and instead wanted to call up horse shows, since I'm a competitive horseback rider, pretend to be me and see if I was competing. It was very alarming.
Laura, since the judge doesn't know you, can you sort of explain to the court what you're talking about with this horse show thing? And you said competitive.
Yes.
Just briefly explain what that means.
I compete in horse shows regularly.
Okay.
I haven't lately, but I have, yes.
And those horse shows are in Arizona or elsewhere?
In Arizona and California.
Okay, and so in this video, it appears the defendant was encouraging people to call up places that he thought you might be to find out if you were there.
Yes.
Did that cause you any alarm when he said that?
Yes.
Okay. Laura, did you see the corrected affidavit that the defendant filed in this case?
Yes, I did.
And that came in, unfortunately, after we submitted our exhibit, so I don't know that it is an exhibit. But can you tell me, did the defendant's corrected affidavit cause you any concern? And I have a copy here.
Oh, yes, that was very troubling. Yeah.
Go ahead. And this is an exhibit?
It's not our exhibits because we received it after we gave you our exhibit.
Oh, okay. Is it a defendant?
We filed it with the court, so it's part of the record.
Is it a defendant?
Your Honor, we filed that with court.
Okay. So it was attached to the motion, or it was submitted as an exhibit?
It was attached to our reply brief, which we tried to file electronically Tuesday night and then filed on paper yesterday.
Oh, okay. I haven't seen that.
Okay.
Would you like it, Your Honor?
No, I meant the reply brief. So I haven't seen. If you don't give it to us, if you file it, it doesn't just immediately. Okay.
I emailed it to your assistant Tuesday evening when I thought I had filed it.
The reply brief? I don't think I received a reply. I got the motion and the response though.
Yeah. I have copies of it if Your Honor would like to see it.
Okay, how long is it?
I think it's 3 pages.
Okay.
It's 7.
Pretty short.
It's 7.
Okay.
And I've received it, and I have no objection to any of this. This is fine.
Okay.
But you're asking me about this one, right? The 2-page one?
Yeah.
Okay.
In a minute, we're just going to, the judge hasn't.
May I approach you?
Yes. Thank you. Sorry about that. We're oh wait, it was filed yesterday? Oh no, this was a copy that you got a conformed copy.
That's right, Your Honor.
Okay. All right. I'll try to read it. I'm going to listen at the same time, so we'll see how I do.
Yeah. Okay. So, Laura, at some point, the defendant filed a corrected, he filed a declaration with his original response, and then he filed a correction. And you saw the correction. In fact, you're holding it in your hand. Is that right?
Yes.
Did anything in that correction concern you?
Yes.
What?
May I read just
tell the
paragraph? Okay. So in his first declaration, he said that he had not been anywhere except for the courthouse to see me, and I understand that court proceedings are public. So he then corrected his declaration on February 17th to say that he realized that the statement was incomplete and incorrect, and that in October of 25, he did attend a horse show in Scottsdale after seeing an online posting stating that I would be there. And so it was very upsetting to me because he obviously knew that he had gone to the horse show when he initially wrote his declaration. And just knowing that he looked up where I was going to be in October and went to this event, even though it's a public event, went after seeing that I was going to be there. Like, he didn't just go to see a public event. He went because I was going to be there. And I had no idea he was there.
Okay. And do you recall, you may have said it, but what was the date of the horse show that he's now acknowledged that he went to follow you to?
October of 25.
So within the last year?
Yes.
Okay.
Correct.
All right. Laura, let's move on from that. I've got another exhibit, which is my exhibit I, which is going to be hopefully plaintiff's exhibit 9. Let's do this.
The guards there will will say wrap
Your Honor,
her ass,
Okay,
and then she'll be impregnado,
okay.
even if
Yeah.
Okay, go ahead.
Your Honor, this exhibit has been a clip job, Your Honor. It is a number of clips taken out of context and mashed together. It's in violation of Rule 36, and we strongly object to its use in this.
Okay, and is this clips of multiple videos?
I think it's obvious from watching it that there are edits that have happened, and there's a rule of completeness. They can submit the full thing if they want to. We're talking about a 4-hour video that I don't have time to play. So
Okay.
I'm entitled to give summaries of evidence, and this is, if he wants to, on cross or during his time, explain what's missing from this. Again, I don't object in submitting the whole thing. It's 4 hours.
Right.
So we just don't have time to get to that.
Okay, and so you would prefer the full 4 hours?
Your Honor, I would prefer that whatever clips they use are presented in their full context, which they could have done if they had submitted the full video and then gone to the spots that they wanted to show. They didn't do that. They did this clip job, which is a materially misleading, formulation of this evidence.
Well, but you have the ability to present clips of the video as well, right?
That's true, Your Honor. We also have transcripts of the videos that we have submitted into this. As
Okay, so I'm gonna let him play because of the length of the video. I'm going to let him play the portions he wants to play, but I'll also let you play any portions that you believe are appropriate for me to consider any context. Okay?
Your Honor, just two comments for the record. First, the rule of completeness first, it allows me to use less than the whole thing. And if there's an objection, the correct response is to have them submit the entire thing if they think that we've done something misleading. That goes to the weight of the evidence, not the admissibility. And if there's some part that's been excised or some editing that's been happened in some way that makes it misleading, that's for Your Honor as a fact finder to use that as a credibility issue or whatever. But it doesn't mean that you can't watch it now. So having said that, let me just rewind this here.
Okay.
And again, we're not suggesting that there aren't edits. You can see them. You can see that there are cuts.
The guards there will wrap her ass, and then she'll be impregnado, even if there's more than one, and watch her end up with twins or more. Can you imagine the irony of it all? Lie. Cry wolf, cry wolf, cry wolf, and all of a sudden, boom, knocked up with more than one child. Man, that would be a showstopper. This story does not end with jail. I'm letting you know that now. It's fed for free on my tax dollars. Thank you very much, you cunt whore. And you get to probably walk the yard. Might not be with your service animal, but you'll make some lady friends in there, I'm sure. And if they don't call her Horsehead, I don't know what they're thinking. I believe the women in prison will say, hey, Horsehead, get over here. It's a perfect nickname, don't you think, versus what she's come up with. Emily. It's a really good spooky movie. I think I want to be called Emily. That's a childhood talking again. Don't you think that's a child? I want my name to be Sally. Well, your name's Laura. Deal with it, you fucking idiot. Okay, jazz hand like the fucking best of them. Well, she hit me, knocked me into the wall. I can't do it in her voice without going to the mic, and then the mic causes me bright light. Your Honor, no, don't put me in solitary because I can't. I've got anxiety. Yeah, she'll be a bitch they toss around. Exactly. I wholeheartedly agree. Sorry. I'm so sorry. Maybe there's a sisterhood there we don't know about. They'll become co-representatives for the standing up against DV. Oh, fuck me hard. I'm sore right now just by saying that. Ow. Oh, he's in a pod, and it's all about the women in that family who can't wait for Ron to, shall we say, pass on. Scary shit. You have to wonder how toxic her relationship with her mother is. Yeah. Who hits who? Let me just leave it with that thought.
Okay, Laura, the exhibit that we just played, do you recall when you first saw that?
It was recently.
And this is cited in your petition, is it not?
Yes.
Okay. And in that video, the defendant made jokes about you being raped in prison, impregnated with prison guards' children. He joked about your father dying, who happens to be here in the courtroom in a wheelchair. Did any of his comments, and he said fuck you and other things, which I understand you can say those things, but did these comments from the defendant harass you? Do you feel harassed by them?
Yes.
All right. And also, Laura, how many videos has he posted about you?
His playlist includes 1,400 and some he's added 155 since the injunction was granted. And I'm not saying every one of them is his, but this is a playlist of videos about me.
So the defendant has a YouTube channel, and on that channel are videos that he has himself created, apparently, right? I mean, he appears in them like this.
Correct.
And there's also videos that he has not created but are about you, and he's gathered them together and put them on a playlist.
Correct, and that's what I put in my petition.
Do you know roughly the number? So the playlist speaks for itself. It's 1,500 and whatever the number says. Do you know how many videos he's done himself about you?
I believe he said it was 400, but I'm not sure.
How many of those have you watched?
I only saw 10 when I read the transcripts of 10 when I did my petition. I couldn't go through them all.
Okay, and of the 10 that you saw, how many of them contain sexual references to you or sexual comments?
Everyone.
Okay, and we're going to get to that. All right.
Hello? the poor indigent. If she goes and says I'm indigent because the court said so, I'll fucking bitch slap her through the phone, through the camera, whatever I can get to her. She's a fucking twat. She's a hole. She's an oblivious hole. And to take from Lauren's vocabulary, no is a cunt. And recently, a bloody ass cunt. I needed to go hang out at the hospitals and find out if she was admitted anywhere or actually had surgery. Not just a hangnail up her ass. Michelle, money, show us the money, dumbass bitch, and parents. That one's me, right? I called that. I said, show us where all the money is as far as legal fees, law firms, and both case-related monies. Important to know. Indigent my ass. Did you hear this morning? Last night even, via Omar's stream? Well, my parents, I bought a ticket and then I canceled it because I thought you said we didn't have to be there. And then my parents bought me a ticket at 7:30 last night. And then at 5:30 this morning, I canceled it because I was bleeding out of my orifices. Well, when you shove laxatives in your mouth and suck on them like candy, it's going to raw it out. And if you're purposely vomiting so you can say that you're anorexic, first off, you just offended every anorexic person who really is anorexic in the world, including the moon for that fucking matter. Second, you're doing it to yourself. That's why you're vomiting blood out of your throat. And how much blood is it? You're 84.6 pounds. If you were to vomit blood out of your mouth, I think you'd pass out. If it's a spit full of blood in a tissue, I pass more blood when I pass a kidney stone, you fucking bitch. Fuck.
Laura, the video that we just saw, when do you recall? First of all, did you ever watch this on YouTube?
Yes.
And do you recall when you saw it?
It was, he's referring to something after November of 25, so.
Was this within the last year?
Yes.
And this was identified in your petition, and you made a mistake regarding the video number, is that right?
Yes, in regards to the bitch slap.
Well, in fact, in the little title footer there, it says Exhibit J, Incident 6, bitch slap, video 273, not 272. Is that the mistake? One of the mistakes that you made in your original petition? You called that video 272, but it was actually 273.
Correct.
All right. And Laura, in this case, you're aware that the defendant submitted an affidavit or a declaration sworn under penalty of perjury. Paragraph 22, he says, Owens falsely alleges that during this live stream, I said, if she goes and says I'm indigent because the court says so, I'll fucking bitch slap her through the phone, through the camera, whatever I can get to her. And then he says this statement appears nowhere in the transcript or in any other live stream Owens cites for that matter. Do you believe that to be a truthful statement from the defendant? And in his motion to quash, reading from page 2 at line 15, he says, contrary to Owens' mischaracterizations and outright fabrications of what the defendant said, nothing in those live streams meets the criteria of the harassment statute. Did you fabricate any part of what I just played in this video?
No.
Did you fabricate any part of any of the videos we've seen so far?
No.
All right. Did that video cause you to feel alarmed, distressed, harassed in any way?
Yes.
I would think. All right. Let's look at Exhibit K, which is going to be Plaintiff's Exhibit 11.
Yeah, I got to see Lo handle who's in charge in her pod or whatever the fuck they call it, and then her take that person down so that she can be king shit, right, or queen shit. That would be quite interesting. And I don't see her doing it. I see her cowering in the corner and possibly even forced to solitary or not commissary. That's food where you buy stuff. The hospital, because what people might potentially do to her in the showers, whereas all they can do, I assume, is slide food through a little rectangle door. She could probably work her magic through there with a couple of blowies, but we don't know for sure, right?
Laura, that video, do you recall when you saw that?
It was recently.
Okay, and his comment in the video about you performing magic, doing blowies through a little hole in the door, did you understand that to mean a sexual reference to you performing oral sex on prison guards?
Yes.
Did that statement harass you in any way?
Yes.
All right.
Until she come in and say, I know nothing about this case.
This is my Exhibit L. It's going to be Plaintiff's Exhibit 12.
woman, which we all thank God for that in most of our lives, right? I have seen her, not met her, but seen her up close and personal. So keep that in mind too. I talk shit like this, and I'm talking with valid, and I try to support my verbiage, right? When I document something, I write it down, or I'm saying the F word a lot, it's because I'm passionate. But on top of that, I've actually stood next to her, stood near her, stood in the gallery, not 5 feet away from her. You all don't have that pleasure. So it's a different perspective that sometimes I have to think, look at her, she's right there, and she blew Clayton twice. She wrote all those text messages. She has the audacity to be standing in this courtroom and not yell, I'm guilty, take me away in chains. Ooh, baby, ooh, baby, ooh, baby, ooh, right? Maybe she's into that too. I don't know. We know she's not into cleaning her casita. But I say all these things because they also cross my mind because I've seen her in person, right? Or the other, right? Makes sense to me. Plus, we don't want to leave her out there in the world for too much longer, right? She's probably getting a little restless in the downtown area, and she needs to find a new man. Scary thought, but the holidays are coming, right? Have a drinky, and boom! Uncle Bob's your uncle. What is it? Bob's your uncle. That's it. Bob's your uncle. I never liked Bob. Just call me Robert or Rob, okay? Please. Start with Robert. I prefer that the most. And if you were my mom, Roberto.
Laura, that video, do you recall when that, first of all, you ever seen that before?
Yes.
That looks like it's a phone recording a tablet or something. Did you create that?
Yes, I did, because the video was 4.5 hours long. I couldn't clip it.
When do you recall seeing that for the first time?
Maybe a month ago.
And was that around when it was posted, do you know?
It was definitely within the last year. I'm not sure when it was posted.
Okay. Let's look at Exhibit M. This is going to be Plaintiff's Exhibit 12.
Me in the face, and the police are called, and they take me to jail. Then I could be arraigned at the same time. Wow. That would be almost as good as flying on an airplane to California from the 4th to the 6th, seated near her, if not next to her. Then I could bet she would let me join the Mile High Club. I killed it myself.
Laura, that video, have you seen that before?
Yes.
Do you know when he posted that?
It must have been November of 25.
Okay, and that's part of your petition in this case, right?
Yes.
And in that video, he made a comment about sitting next to you on an airplane, and that if he did that, that you would let him join the Mile High Club. What did you take that statement to mean?
That I would have sex with him.
He's made a lot of sexual comments about you, hasn't he?
Yes.
In fact, almost every video we've seen is about sex with you. Laura, you have a pending criminal case. You have a mugshot up there, and there's a reference to that. That's a matter of record. We all know that.
Yes.
How many times have you been in court on that other case? In person appearances?
Maybe half a dozen.
Has the defendant been at every single one of those?
Yes.
Okay. Did this video make you feel harassed or alarmed or humiliated in any way?
Yes.
All right.
Which exhibit? I'm sorry. That was
That's our Exhibit M. I believe it's Plaintiff's 11 or 12. Oh no, I'm sorry. There are. Drew, I owe you an apology. You matched. That would be Plaintiff's 13. I see.
Okay.
There are cross references to our. That makes it much easier. So let's look at our Exhibit N, which is going to be Plaintiff's 14. Oh. Hang on, this one's 43 minutes, so I think we are going to not play that entire one. In fact, the rest of them are just too long to play. Laura, watching these videos and knowing that the defendant has posted about you more than 400 times, well, whatever the number is, it's more than 2 in the last year, is that right?
Correct, yeah.
And you feel harassed and humiliated by that?
Yes, correct.
And what are you asking the court to do about that?
I'm asking the court to, I guess, sustain the injunction, to keep the injunction against harassment.
I'm sorry, I actually missed one little bit. After the defendant was served with the order in this case. Do you know approximately when that was? You filed the petition.
Oh, yeah.
You filed it on January 20th, 2026, and I believe it was issued that same day. Do you recall when he was served with it?
I believe it was January 26th.
After he was served with the order, did he do anything else to continue harassing you?
Yes, he did.
Can you explain what he did?
He continued to appear on podcasts or like YouTube shows, and made comments about this. He even said there's no stopping him now, was one of his comments.
Did he make a video where he showed the injunction against harassment as part of the video?
Yes, he did.
And it had your name on it?
Yes.
Did he make a comment at any point about going to your house and knocking on your door after he was served with the order?
Yes.
Do you remember when that happened?
It was maybe a week after.
I have a quote here that says in a video on February 5th, 2026, the defendant said, "Well, I knocked on her door at the casita. Who's knocking on the door? But then I just maybe thought that's a bad idea and I left." Do you remember seeing a video where he said that?
Yes, I do.
Did that terrify you?
Yes.
And you understand that he concluded that statement by saying, "I'm just joking."
Yes.
Did you think that was funny?
No.
No further questions, Your Honor.
All right, thank you. Cross-examination?
Thank you, Your Honor. Good morning, Ms. Owens.
Good morning.
How did you find out about Mr. Andreev's videos?
I was searching my own name on YouTube, and his large volume came up. Because I'm curious to know what people are saying about my case. I think it's important to be aware.
So you had to affirmatively go up looking for videos about you, right?
Correct.
Mr. Andrejev did not send any of these videos to you, did he?
No, but he addresses me as a person within them. You cunts and everything is at me. Yes, he did by attending the court proceedings and by going to a horse show he knew I would be at for the purpose of watching me.
Did he say anything to you?
Yeah, I mean, he said hello. I held the door for him.
So is hello harassing?
No, hello is not harassing. The other acts are.
And your court hearings are public, aren't they?
Yes, and he also has the right to speak about me, just not say what he said.
And when you eat in a horse show, that's a public event, isn't it?
Yes, I've never had a stranger come and try to watch me. I will guarantee you nobody else has ever sought me out like your client has. No.
But you testified.
Correct, and he lied in his petition and said he was only going to court proceedings. He knew he'd been at a horse show.
And you know, of course, that Mr. Andrejev did submit a corrected affidavit, corrected declaration, correcting the mistake that he made, and letting the court know that yes, he did attend that horse show last October, right?
Correct, which scares me even more because I don't know where else he may have been that he's forgotten.
But you've never seen him anywhere else, have you?
No, I have not.
He hasn't contacted any members of your family, has he?
No, but he certainly made comments about them and that my mother and I are out to poison my father. He has attempted to communicate with other people who are doing legal shows about me, and Rachel Mitchell, he's attempted to, he has contacted about my case.
To speak to a public official about that public official's public duties, right?
Absolutely not. No.
You still have Mr. Andrejev's initial declaration in front of you?
I only have the supplemental. I'm sorry. I only have the supplemental.
I've got a copy if it would help.
Yes, may I?
Sure, go ahead. This is the declaration that was attached to the motion to quash?
That's correct, Your Honor.
Okay.
Thank you.
Oh, I'm sorry. I hadn't even noticed, but yeah, there's no microphone at the podium.
Oh.
So you can stay over where the microphone is, or you can use that microphone and stay at the podium.
Yeah, I'd rather see it at the podium.
Yeah, that's fine. I'm sorry. I forgot. This is the only courtroom I've been in that doesn't have a microphone at the podium.
Ms. Owens, can you read paragraph 22, please, out loud?
Owens falsely alleges that during this live stream at 16:31 to 16:37, I said, if she goes and says I'm indigent because the court said so, I'll fucking bitch slap her through the phone, through the camera, whatever I can get to her. Petition at 5. That statement appears nowhere in the transcript or in any other live stream Owens cites for that matter. See generally Exhibit 5. Owens alleges that I made other statements that appear nowhere in the transcript, including she's a fucking twat, she's a hole, low as a cunt, and recently a bloody ass cunt. Petition at 5. These do not appear at the timestamp she cites or anywhere else in the transcript. See generally Exhibit 5.
And directing your attention to paragraph 21, the live stream that is referenced in paragraph 22 is the one cited in your petition titled 0272 Trial LOVMM Travel Granted, correct?
Yes, and then I corrected it to 0273.
But you didn't correct it until after we had submitted this declaration, right?
Correct, but I cited all of his videos in the first paragraph of my injunction.
Did you cite every single video by name and number?
Well, I said 1,300 of them.
So it's true, isn't it, that these quotes that are discussed in paragraph 22 do not appear in the 0272 video, do they?
Correct, but he said them and we played it. So I was just a clerical error.
So it's true to say that those statements do not appear in that video, right?
Correct.
So this is not a lie, is it?
He says that it says at the time, it says that they, okay, correct. And within this, I believed that he had said that they don't appear. Oh, at the time stamp she cites or anywhere else in the transcript. Within this transcript, no.
Yeah. So you're falsely accusing my client of.
No, your client said these statements, and he said them in there, so it doesn't matter which one he said. These were incredibly offensive and scary to me. So I think I understand where you're going with this, but I think you're barking up the wrong tree here because he did say them.
You know, of course, that it is physically impossible to slap someone through a phone, right?
He said whatever I can get to her.
You know that it's impossible to slap someone through a camera, right?
I don't know what he meant, however he could get to me. That could mean in person.
So that's obviously, it's obviously a figurative statement, isn't it?
Everybody here knows what he was saying.
So, if these videos were upsetting to you, why did you watch them?
Because I wanted to know how far he was going to take things after I learned he was trying to get people to impersonate me. That's when he really came on my radar.
But you didn't even know about them until you went out looking for them, right?
Until I saw videos with my name on them, yes. And as I said, the volume of videos is overwhelming.
And again, you never saw him anywhere other than at your public court hearings, right?
Yes, which creeps me out so much more because who knows where else he's been. And he said he needed to hang out at hospitals to try to find me. So for all I know, he went to the hospital when I was admitted. I don't know.
So you have no evidence that he did, right?
He said I needed to go, so I don't know.
You're just speculating, right?
Correct.
Mr. Andrejev isn't the only person that talks about your cases online, is he?
No.
And he's also not the only person who talks about your cases online that uses, shall we say, vulgar language.
Correct, but they don't try to direct people to impersonate me or say that I should be raped by prison guards.
So let's talk about that. Did anyone, to your knowledge, impersonate you?
Yes. Yes. They did. I was told that they called the horse show office. Yes.
Okay, tell me about that. Who told you that?
I was told that by the horse show office.
Who at the horse show office?
I can't give a name, but I'm sure if you call the horse show office, they will say that they received calls trying to pretend they were me.
Were you competing in a horse show that weekend?
I was not.
So even if somebody called trying to impersonate you, they wouldn't have gotten any information about you, right?
They would have found out I wasn't there because your client told them to call to see if I was there.
But nobody got any information about you, did they?
Yes, they did. They found out I wasn't there.
So let's talk about the statement about guards potentially raping you in prison. Isn't it common knowledge that unfortunately sexual assault is a problem in prisons?
I'm sure. I don't know enough. I'm sure it is. I'm not denying that. I just don't know enough.
So it's something that people talk about when they're talking about a criminal case where someone might go to prison, right?
Not that I've seen, but I haven't sought that out.
So it's certainly not unreasonable to speculate that if someone is in prison, they might unfortunately be sexually assaulted by a guard.
And impregnated by a guard? Is that with multiple children? No, I don't think that's common.
You spoke about what you say that my client said in a live stream shortly after he was served with the petition.
Correct.
Correct. And you testified that he displayed the petition on screen during that live stream, correct?
Correct.
Is your address on that petition?
I don't know.
And you said that he said something about visiting the casita where you lived, correct?
Correct.
And he immediately followed that by saying that's a joke, right?
Correct.
So he was joking.
It was an extremely poor taste if it was a joke, and for all I know, it was the truth. I don't know why somebody would say that and think it was funny after they've been served with an injunction against harassment.
People are allowed to make jokes, aren't they?
If it was a joke, and no, I don't believe that he should have been allowed to say that, or who would say that after they've been served with this.
So people are allowed to make jokes in poor taste, right?
Yes, they are, but not about stalking somebody after they've been given an injunction against harassment. I think that was alarming to me.
So you're upset because Mr. Andrejev has criticized you online, right?
Absolutely not. He's entitled to criticize me as much as he wants, and that's why I allowed this to continue without getting an injunction for more than a year. I wasn't seeking out his videos.
So you knew about his videos for more than a year before you filed the injunction?
Correct. I hadn't watched them, but I knew he was a content creator who did videos. It was only once I learned that he was trying to get people to impersonate me that I thought maybe I need to look more into this.
And again, you didn't have any knowledge of the content of any of these videos until you went out looking for them, right?
No, that's not true. It was when I found out he was trying to impersonate me that I started looking into the content of his other videos.
Okay, so what made you look for the content of his videos was when you found out he was telling people to impersonate you?
Correct.
That's not what you testified before, is it?
No, I don't know what you're referring to.
You testified that you went out looking for videos of yourself on YouTube.
By my name, correct.
Right. But now you're saying that what precipitated that was your alleged knowledge that someone had impersonated you?
Correct. Then I looked up my name and I saw all the videos that he'd created about me.
So who told you that someone had impersonated you?
The horse show office.
And did you call them or did they call you?
They called me.
Okay. And did that person say that the person who was impersonating you was doing so because of Mr. Andrejev's YouTube posting?
No, they did not.
Now, you know that there are quite a few people who make statements on YouTube and other social media stating their opinion that you're guilty of the crimes that you're charged with, right?
Correct.
And you didn't seek an injunction against any of them, did you?
I did not.
You just picked on Mr. Andrejev because he happens to be here in Phoenix, right?
Absolutely not. It was because he tried to get people to impersonate me and made very vulgar sexualized comments about me that other people have not made. They've criticized my case and they have every right to criticize me in my case. They don't have the right to take it to the level that he's taken it to.
So you think it's illegal for someone to make vulgar comments about you?
No, absolutely not.
But isn't that what you just said?
No.
You got the injunction against him because he made vulgar comments about
No, I said I got it because of the impersonation and the sexualized comments he made about me being raped and then trying to monitor my status. Nobody else has actually gone to these events and tried to put themselves on my radar, I guess I could say, like he has. And he's tried to make it like, oh, I have been near her and she's, given blowjobs to these guys. That's taking it to another level that other people aren't.
The case underlying your criminal case is the paternity action that you filed against Clayton Eckert, isn't it?
Correct.
And in that case, there was testimony that you gave Mr. Eckert 2 blowjobs the night that you claimed to have been impregnated, correct?
Correct.
And the judge in that case made factual findings that it was not possible that doing 2 blowjobs could result in a pregnancy, right?
I'm going to object to that as being way outside the scope, and it's also not an accurate statement of what the judge found. You could take judicial notice of what the judge found. I think the court has the ruling from the prior case. I have no objection to you taking judicial notice of that, but what I just heard is not an accurate reflection of what the judge found.
Your Honor, please do take judicial notice of that ruling, and this is something
Where was it? It was provided in attached to what?
I don't believe it's been provided to you yet, Your Honor.
Oh, you're asking I could judicial notice from the court's own records, you mean?
Correct. I can provide a copy of it, Your Honor, if that would be convenient.
So my understanding is, and this is from the pleadings, right? That's what I know. There's, I'm sure more, right? But so from the pleadings, which I did my best to review, but one of them was like this, and I have many, many cases, and so I have done my best to be prepared for today. It was rushed, I'm sure, for both of you as well because of the short time frame. So my understanding, and you let me know if there's more that's important, but my understanding is there was some paternity or type action or a lawsuit filed regarding an allegation of a pregnancy against a gentleman who took part in The Bachelor. That case, the end result, I don't know precisely what it was, but the end result was that the judicial officer found Ms. Owens not to be credible, so that case did not resolve in her favor. And the result of that was that she has current charges pending. I saw the charging document, I believe, was attached to what one of you filed, and I saw that. So I'm not sure what exactly you're wanting me to take judicial notice of. So I think the idea that there was a finding that she was not credible in that proceeding, I think is a fair assumption that I have made. But is there something other than that, or something specific to oral sex that you think is important?
Certainly, Your Honor, and that is in the minute entry ruling on the paternity case, which again I can present to Your Honor.
But what's the importance of it?
The importance of it is it provides context for my clients talking about blowjobs.
Oh, okay. Did you want to respond?
Only to add that I was trial counsel in the case that we're talking about, so
okay.
I'm very familiar with the facts of that case. I don't disagree, and we can just stipulate that case.
Okay.
That case involved an allegation of oral sex involving this guy on The Bachelor,
Okay.
and I agree that it provides some context to what we're talking about. So if that's what we're doing, I'll stipulate to those facts.
Okay.
Beyond that, what counsel was trying to describe, and I'm not saying this was intentional, but it's a lot of papers and facts. But what he described the judge found in the prior case was not accurate. So I was trying to help you by saying you could just look at the minute entry from that case if it was important. I don't think it is, because we're talking about an undisputed fact that there was oral sex in the other thing.
Yeah.
So that's why it's being brought up.
So is that, do you agree with that? That the importance of it is the relevance of any comments that your client may have made is related to that other case, and that oral sex was an issue in that case?
That's correct, Your Honor.
Okay. So could we, as a stipulation to what we just discussed, is that acceptable, just to, in the interest of time?
That's perfectly acceptable.
Okay. Okay. All right. I think the stipulation covers it then, and it sounds like that's a whole bunch of stuff. And so if we've limited it to the specific issue, then I think we're on track. Okay.
Thank you, Your Honor.
Sure.
The judge in that case made factual findings, correct?
Correct.
The judge's factual findings included that you provided false testimony, correct?
Correct.
The judge's findings, the judge found that you admitted that you had altered medical test results, an ultrasound and a sonogram, correct?
Again, Your Honor, this is going so far afield, and also there's a minute entry that explains exactly what the court found. I have no objection to you taking judicial notice, although the judicial notice rule says that Your Honor can look at a piece of paper and say, oh, here's what it says. That does not establish the facts. Well, the facts are not, you can't get judicial notice beyond the document itself.
I can make a fine. I can take judicial notice of that judicial officer's findings. That doesn't mean I am aware of like evidence that was presented.
Exactly.
But I think your goal is that there was I think, you tell me if I'm wrong, that she was found not to be credible. If there was a ruling that there was evidence that she attempted to present in court, whether it was physical evidence or testimony, that the court found was not credible or was, at a minimum misleading. I think you're attacking her credibility here, correct? So I understand that. So I think, and I think she's also agreed or admitted. I don't, when I say agreed or admitted, I mean, I don't want to get too far into the weeds, right? About, what you say she did versus what she admits that she did, or right. I think the idea that she was found not to be credible is what you're looking for here. And I think, I take judicial notice that she was found, to not be credible, or that she presented, something to the court that was at a minimum, misleading, altered, whatever the case may be. It's something I will consider with respect to her credibility, right?
Yes.
Okay.
Thank you. Going back to the horse show in Scottsdale last October, several days before that horse show was scheduled to begin, you had a hearing scheduled in California in another Injunction Against Harassment case, correct?
Correct.
And a few days before that hearing, you filed a declaration with the court in California saying that you were severely ill and that traveling to California for the hearing would be life-threatening, correct?
Correct.
And then a few days later, you participated in a horse show, correct?
I think you're missing the fact that I was hospitalized overnight and had surgery.
And then a few days later, you participated in a horse show.
Actually, no, this is entirely incorrect. You're talking about a horse show in October. I was hospitalized in November, and I was at a medical, I'm sorry, I'm getting the dates confused. Can you just guide me to where it was? Because the hearings in California were in October and November.
I'm having a little trouble following too, so maybe
Yeah.
I could ask some specific dates just so I can understand.
So you had a hearing in a injunction against harassment case in California that was scheduled for October 22nd, correct?
A domestic violence restraining order, and the hearing was October. It was October 20th. Yeah, October 20th, I believe.
So sometime around October 20th and October 22nd, right?
Correct. And I had an appointment with a specialized GI doctor that I had to go to, and I could not miss.
But before that October 20th or 22nd hearing in California, a few days before that hearing, you submitted a declaration to that court saying that you had been vomiting blood and that if you were required to travel to California for that hearing, it would threaten your life, right?
Correct. And my hemoglobin levels were almost at transfusion level at that time.
And that was at most 5 days before the horse show in Scottsdale?
When I filed that, I don't know the dates. It was 5 days, 7 days before I competed in a local horse show for a total of 4 minutes.
And you won first place, didn't you?
Correct.
So
days after the hearing. This was not on the day of the hearing or anything.
So you had this recovery from a life-threatening condition that required surgery, and
2 weeks later, it required surgery. 2 weeks later, I was sick from August of 2025 until really now. You can see how small I am. I have been extremely ill.
But you weren't so ill that you couldn't compete in a horse show, right?
You can see how I look in that. I competed 10 minutes from my house for 4 minutes. I didn't miss the hearing for that. And you know I did not miss the hearing for that, and that I competed days later, and so does your client.
And that's what I was asking you, Ms. Owens. But the fact remains, doesn't it, that you told the court in California you had a life-threatening condition.
Which I did, and I still do.
And a few days later, you were competing in a horse show.
Correct.
Correct.
I don't see how that has to do with whether or not your client made statements that he clearly made.
Okay, you just answer the questions, and then your attorney can follow up after.
Okay. I'm sorry.
Let's keep this moving though, because
Yeah.
we're well outside of our time frame here.
Yes, I apologize, Your Honor. Just a few more.
That's all right. You're not. It's not only you, but we got a slow start as well.
Yeah. So when you say that you feel harassed by Mr. Andrejev's videos, you're just making that up, right?
No, I'm not.
Just like you made up things you testified to in the paternity case, correct?
Your Honor, I'm going to object to that and instruct the witness not to answer based on the Fifth Amendment. We are not getting into the criminal stuff and asking her about that. I'm not going to allow her to answer that.
Do you want to be heard?
Your Honor, I think you understand where I'm going with this, so I will withdraw the question.
Okay. All right. I think that makes sense, just given that there's a pending matter.
I have no further questions, Your Honor.
All right. Any follow-up?
I don't think so, Your Honor. Lord, based on what he asked you, is there anything you want to clarify, or do you feel like this could be as much as, were you clear on the dates he was getting at with this horse show thing? Because I was aware of some of this stuff, but I don't even remember what the dates are.
I don't remember what the dates are, and I don't remember what day he went. I know I was not scheduled to be in court that day. I've had a very long, like I said, it was from August of 25 until present. I'm still dealing with these medical issues.
Without getting, because this is a public thing, and this is, I'm sure, going to wind up on YouTube, without getting too personal, can you tell the court what medical issues you're dealing with right now?
Yes, I can. I've been vomiting blood since August. I've had multiple tests and procedures done to try to figure out what the source of that is. I have epilepsy, I have autism, I have anorexia, I have panic disorder. I've got a host of issues.
And you've sought medical treatment for those things, right?
Of course, yes.
But you still rode a horse, right?
Correct.
For 4 minutes.
Correct.
Are you just trying to live your best life notwithstanding your health problems?
Correct.
Okay. Is there anything else you want to clarify?
No, I mean, I guess it's just, I'm not trying to get upset about it. I just feel like, the fact that he made these statements is not in question, and it's just upsetting to have this other stuff, brought up. My credibility is not at issue when we have him on video making the statements.
That's for the court to decide, and I think she's listening very carefully. So,
and also one last thing, I'm not saying he doesn't have the right to talk about the case at all, or that people don't have the right to talk about the case. That's all I did want to add.
I had one question, and then I will let each of you follow up. And I'm sorry, Mr. Gingras, I thought you were finished. So if I was not correct, I apologize for butting in. I had one question, and I'll let you all follow up if you think it's necessary. I just wanted to make understand, because there was some discussion of the health conditions. So did this information come up in the other proceeding or in the criminal case? I'm asking you. You.
No.
So the information, so there was, there in the video, there was discussion of some of the things that you've described. So that's why I was asking, were there health issues discussed in either the case, I guess the first civil case, or in the criminal case?
No.
Okay. So, I mean, I'm just confused about how it was out in the world.
I could probably help Your Honor with that.
Well, I mean, I guess I'm asking her.
Speculation on YouTube.
Oh, okay. Okay.
It's my understanding of, maybe that would.
Did you have an objection?
I do, Your Honor, because I don't believe that records with me to.
You don't believe what's correct?
I don't believe that it's correct that to have anorexia, his example was not
Do you know whether it was?
I
mean, I think she can say whatever she wants to say. If your objection is that what she's saying is not correct, you can ask her questions about it. But do you know?
I had a 50-pound weight loss from when I filed the paternity case until when I was seen in court, and so like the anorexia was brought up by people who saw like my weight before, and then saw my weight, I guess, at the case, but it wasn't like discussed at the case. It was like on YouTube.
Oh, okay, wait. If I'm paying attention, I guess, right? We were discussing a motion filed in a California case.
Oh, in
that case, did you say something about your medical issues?
That I had GI bleeding, yeah.
Oh, okay.
So sorry about that. That's okay.
We testified to that, and I just didn't get it.
Right? It was a DVRO hearing. It wasn't an injunction against harassment hearing, and I did have to, for health issues. Yes.
There was something in the court record, so maybe that's what it was.
Correct.
That's all. I was just trying to connect those dots in my own mind, and if I had thought about it, it was probably clear that that's where it came from. Okay. Anybody have a follow-up about my question? Go ahead.
Oh, not about that.
Oh, okay. Did I bring something else up that caught?
You did not.
Do you have a follow-up to it?
Yeah, may I ask the witness?
Yeah.
Your questions?
Is it about my question?
Yes, Your Honor.
Okay.
So in the paternity proceeding, there was testimony regarding whether a positive pregnancy test was the result of your epilepsy medication, correct?
I'm not sure that was brought up at the case. I don't.
Yeah. Well, I'm sorry.
I don't.
Well, if you could restate that question again. I was there, so I'm very attentive to the accuracy of the facts.
How about I just read from the findings of facts? This is page 5 of the ruling in the paternity case.
Does it reference epilepsy?
It does, Your Honor. It says in the email, respondent suggested that the positive test was the result of petitioner's epilepsy medication.
Oh, okay.
So Your Honor,
Well, that was an email then.
with this is where we get into the technical side of judicial notice. You can take judicial notice that the ruling says that, but that statement itself is hearsay. I can't cross-examine anybody about that.
Sure.
So you can
Honestly, I don't know that it's really relevant to anything here either, how it came. I just was trying to figure out. I think it actually is probably potentially in your client's favor that it was discussed in an open hearing or in a court document, right?
That's correct, Your Honor.
But I don't. It sounds like it sounds like it was to an extent, right?
It certainly was, Your Honor, and that was the point that.
But I don't know how. I don't think it really matters how it was discussed or which case.
Right. I'm just trying to establish
Sure.
the fact that it was.
Yeah, that's sort of what I took from it. I took that it was. There were a couple of proceedings where it could have been discussed. So.
And your client then speculated that I did not.
Wait. You can't.
I'm
That's not
sorry.
the question.
I'm sorry.
Okay, so I think that's established. Anything further? More questions on that issue? Okay, did you have a follow-up on that issue?
No, I was just going to clarify that, and maybe I can just ask Laura. You're not basing your request for injunctive relief against harassment on him disclosing medical information such as your health.
Oh no, not at all.
I mean, he has disclosed or commented about things, but so have other people, and you're not making that part of this request, right?
No.
Okay.
No.
That's all I have.
Okay.
And before we let her go, I just wanted to move, if now's the right time, move to admit the exhibits that we talked about so far, which I believe were plaintiffs 1 through 13. And there's 4 other ones which are long videos.
Okay.
I was going to submit them. It's just part of the record. If they object,
I'll have to review them. So if they're hours,
I don't want to do that to you. I think we have enough. We have to prove 2 incidents. I don't want to prove 200.
well, if you want us to, I'm not saying anybody can't present additional evidence, but I would ask that you tell me where, in the document. So if you're not asking, then, so exhibits 1 through 13, you're asking for the admission of those.
Correct.
And then I know exhibit, is it 2? That was the exhibit that was, something that she had created that you had concerns about, counsel?
I believe that's correct, Your Honor. And we would also like to renew the same objection to other exhibits that were clips that were put together outside of the correct context. Those would be
What's the correct context?
the full context of what my client said before and after.
Okay. But you can present that, right?
I can, Your Honor, but in the interest of time, I would rather just move things along.
Okay. So I'll leave out exhibit 2. But it sounded like, if I understood, that was information that she was testifying to anyway. So exhibits 1 and then 3 through 13 are admitted. I'm going to rely on defense to put on that context or to explain the context, whether that's through playing videos or testimony. So those items are admitted. What else do we need to talk about before Ms. Owens steps down? And did you want to be heard further on exhibit number 2?
No, I don't think we need that.
Okay.
And I was going to read evidence rule 106, which I think Your Honor just completely complied with. If a party introduces all or part of a statement, an adverse party may require the introduction at that time of any other part of or statement that in fairness ought to be considered at the same time. And the adverse party is the one doing that. So as long as that's what the court did and intended to do, then I'm totally fine with that.
Yes, I will hear from defense in terms of the context, whether that's through presentation of parts of the videos or through testimony. You have the opportunity to explain.
And I don't believe, exhibit-wise, I don't believe I've received any videos from them, so I don't know that they can introduce complete, but they have transcripts. And if Your Honor wants to look through that mess, I mean, that's up to you.
Okay. So, okay. All right. So maybe you can discuss it that way. The context you were just referencing. Okay. All right. So can Ms. Owens step down?
Yes, please.
Okay. You can step down, ma'am.
Thank you, Your Honor.
Welcome.
Can we maybe have a 5-minute break for everyone's comfort and so forth?
Sure. If anyone needs a bathroom break or to get a drink, we'll take a 5-minute recess and then we will restart with a defense case. You're no more witnesses, correct? Okay. And Mr. Andrejev. I was close, maybe? Close? Okay. Okay. All right. Then you're calling Mr. Andrejev?
Your Honor, in the interest of time, I would like to testimony here,
Oh, okay.
the closing statement.
Okay. All right. Then plaintiff will start.
Well, okay, yeah, I guess that's fine. Do you want me to argue from here or from here?
Either way, as long as
Microphones
you have a microphone, either place is fine.
Microphone's better here, Your Honor. This is first of all, I'm a lawyer in a number of ways, but I definitely consider myself to be a First Amendment lawyer. I've litigated tons and tons of First Amendment cases, usually on the defense side. Very rarely am I on the plaintiff side. And I love the First Amendment probably as much as, being a lawyer. I really was proud of Laura for explaining to the court that she does not object to people talking about her case. She couldn't take that position. I wouldn't support that position. The First Amendment allows people to speak, especially when there's matters of public interest and concern. A criminal case is a matter of public interest and concern. People can talk about the case. There's no objection from our side to that. What you saw from the evidence was not Mr. Andrejev talking about the case. He was talking about Laura in a sexual, violent, disgusting manner that has absolutely no value under the First Amendment because, Your Honor, there is conflict. As much as the First Amendment protects the right to speak, people have the right to live their lives in peace and free from harassment and threats. And I think Laura put it best when she said that she really tried to not pay attention to the defendant until he went too far. And that comment about inviting people to, hey, let's make a phone call and pretend to be L-O, Laura Owens, that was scary to her. And it absolutely was appropriate for her to be scared. And I was thinking about how I could explain this. I think you're getting it, so I don't need to go too far with this, but I'm going to just hypothetically pretend that somebody didn't like you, didn't like a ruling that you made, and they made a YouTube video saying, hey, the judge has some kids and here are their names, and why don't we call up every school and see where they go to school and pretend that would, if somebody did that to Your Honor, they would be in jail immediately and belong there. And if they tried to use the First Amendment as a defense, good luck. I know the First Amendment extremely well. Threats, harassment are not part of the First Amendment. And what you saw and the impact that you saw on Laura, having to sit through that and watch that. And it's an interesting argument as far as the LaFaro versus Cahill case, which is it's cited in the pleadings, and it's an important enough case I wanted to briefly mention it. That case involved a verbal statement made in public in the year 2000, so 26 years ago, between two political candidates for Tempe mayor. And one of them was standing out in front of the library in Tempe, and they made some comment that the other side didn't like that led to a harassment injunction proceeding. And the court said, nah, that's, a verbal statement made to a crowd is ethereal. It drifts in the wind and it goes away. That's not directing contact with or directing conduct at a person as required by the harassment statute. I've cited, for Your Honor, 2, maybe 3 cases. There are 2 unpublished ones and there's a published one. I think it's Snyder, Williams, and Raber, which is in our pleadings. Those are recent cases with completely different facts involving this type of social media harassment. And the law is crystal clear. It does not matter that the defendant didn't send anything directly to Ms. Owens. If she found out about it through any means, it's still there. He took some of the things down, and that's nice. I appreciate that. But having these things online, social media, is an entirely different animal. It is categorically different than words spoken to a crowd. And I know because Mr. Andrejev has done the same thing to me. We haven't even brought that up. But he's posted videos about me, and you saw in one of that scary voice one, there's some sort of an art thing which shows me and Laura standing next to each other. I've represented her for a couple of years, and so people that don't like her, by extension, don't like me. That's okay. I don't have a problem with that. But the point is, I've been a target as well, and I know what's scary about this sort of thing is these statements are online forever. They're around the world. And unlike talking to a crowd at the Tempe Public Library and you say a word and the crowd disperses and it's over, these things are online forever, and Laura doesn't know who's seeing them. She doesn't, all it takes is one lunatic. I mean, you look at the environment, the climate these days with like Charlie Kirk being shot in the neck in Utah. And I posted a video a while ago. I used to put things on YouTube. I don't anymore. But the governor of Utah came forward and did this interview with 60 Minutes, and he did such a good job explaining that, you know, social media attacks, it is a First Amendment thing to a point, and then it becomes too much. And it becomes scary. And in that case with Charlie Kirk, you know, he sort of was a very high level public figure, and he said some things, somebody didn't like it, and they killed him. And the governor of Utah was making this impassioned plea on 60 Minutes to turn the temperature down, stop harassing people and threatening people and riling people up. And I think, again, Laura's going through an extremely difficult time in her life dealing with a criminal case. Anybody would be having a hard time with that. And she understands the criticism as part of that. She doesn't object to that. But talking about having her be raped in prison, having Mr. Andrejev say that he wants to sit on a plane next to her and join the Mile High Club. Well, I will tell you that before I did my brief in this case, I went and read I went on Westlaw and I got the Injunction Against Harassment statute. I read every single case, every single annotated case I read. I did not find a single case that was as offensive as what I've heard in this case, or as scary. People have been sent to prison for much, much less than what we've heard today. And so I love the First Amendment. I respect the First Amendment. When you get this dirty, you lose the First Amendment rights at some level. It's sort of like a Second Amendment thing. You have a right to have a gun. Mentally ill people aren't allowed that right. Mentally ill people can't have a gun at all. And based on what I've heard, I don't see any problem with the court restricting Mr. Andrejev in the way that it already has. So you should affirm the order. I would actually ask that you expand it. I would want an additional proximity limit where he's not allowed to come within 500 feet of her. I would actually ask the court to make that specifically include court hearings. I found out yesterday, unbeknownst to me, in her criminal case, Laura's criminal defense lawyer filed a request for her to appear virtually at a case management conference coming up because of Mr. Andrejev, because he's attended every hearing, and we're dealing with this scary content that he's put out there. So Laura's explained to the court she doesn't even feel safe coming to court because of him. That's unacceptable. That is totally unacceptable. So I would ask the court to affirm the order and add a proximity restriction that includes he can't go to court hearings. He can watch them virtually. He can read the transcript. He can watch it on YouTube. He should not come to court and scare her anymore. Obviously, we're asking for fees. It's obviously in the court's discretion. I don't believe we should have even had to come down here today. There's no dispute that these comments were made. He submitted paperwork to the court that accused Laura of fabricating. And I understand there was a bad adverse ruling, which we are dealing with, and I don't agree with. I understand judges make rulings, and I respect them always, but I don't always agree with them. There was an adverse finding about her doing some things in the other case. She hasn't done anything in this case but tell the truth. And he hasn't even challenged a word that she said as far as what he's accused of doing. So we shouldn't have had to come down here. He should have to pay for that time. So I'd ask for the award of fees. Your Honor, I also made a request for a criminal referral. That's up to you. I understand as far as I explained and I accused Mr. Andrejev of perjury. I think what he did was perjury. I understand, and there's a case called Braunston versus the United States. It's a U.S. Supreme Court case that deals with you can't be charged in a federal court with perjury if you said something that's literally true, but it's really misleading. I get what their argument was, that he was denying making a statement in video 272, but actually he knew that it was 273. That's up to the court. If you want to make a criminal referral, I just want this to stop. We should not have to deal with this. And the fact that we're even talking about this, it's just inappropriate. So affirm the order, expand it, award fees, and do what you want with the criminal thing. And if you have any questions about the legal side, I've cited the case law for you. There's no argument from their side that harassment is protected speech. It's not. Because harassment is a different thing. When you terrify somebody, when you do what the type of things that we've seen here, that's just outside the First Amendment. So there's not a legal issue in that regard.
All right, thank you. And from defense?
Thank you, Your Honor. This case is not at all the open and shut case of harassment that plaintiff and her counsel would have you believe. This is about a defendant in a high-profile criminal case trying to silence an online critic. You heard her counsel ask for an order that would prohibit Mr. Andrejev from exercising his First Amendment protected right to attend public proceedings in a criminal case. You heard her testify that he has never, ever communicated directly with her. The only thing that he might have said to her is maybe hello when they passed each other in the context of a court hearing. He hasn't been intimidating her via appearing at court hearings. You know, counsel says vigorously in his papers as well that the First Amendment does not protect harassment. Of course it doesn't. We don't argue with that. But what you have here is not harassment. As we've shown in our papers, Ms. Owens cannot prove, and she has not met her burden of proof here, to prove 3 out of 4 of the essential elements of harassment. Mr. Andrejev's comments were not directed at her. Mr. Andrejev's commentary about her court cases has a legitimate purpose because it is fully protected by the First Amendment as speech about issues of public concern. And none of the comments Ms. Owens identified or presented to the court today would cause a reasonable person to feel harassed or threatened. If we're able to have injunctions against harassment because somebody said mean things about somebody else on the internet, we'd have to have injunctions against half the people against the other half of the people. It is not against the First Amendment and it's not against the law to say mean things about someone on the internet. It's not against the law, it's not harassment to use crude and vulgar language about somebody else. Certainly, Mr. Andrejev has strong opinions about Ms. Owens, including that she has misused the courts to unjustly persecute her perceived enemies. You heard that in Exhibit 5. And, you know, unfortunately, Your Honor, she's doing it again. She's doing it to him. He criticized her for what he believes is her misuse of the court system. Now she's doing it against him. As Your Honor knows, the elements of harassment under ARS 12-1809T are that it is 1, directed at a specific person, 2, that it would cause a reasonable person to be seriously alarmed, annoyed, or harassed, 3, that it actually caused the victims to be seriously alarmed, annoyed, or harassed, and 4, serve no legitimate purpose. Taking the 4th element first, and notably in his presentation, Mr. Gingras didn't mention that particular element. But as we explained in our papers, Mr. Andrejev's speech here is commentary about issues of public concern that has the highest protection under the First Amendment. The U.S. Supreme Court held in Snyder versus Phelps that vulgar speech that causes emotional distress, speech that is really reprehensible, cannot be punished if it is speech about an issue of public concern that is not otherwise a true threat or true harassment. Mr. Andrejev's speech serves a legitimate purpose, so it's not harassment as a matter of law. To the first element, Mr. Andrejev's commentary is not directed at Ms. Owens. He posts it on the YouTube for the world to see. He has not communicated it directly to Ms. Owens. She had to go out looking for it. He didn't direct it to her. She had to go look for it. It's about her, sure, but it's not directed at her. And let's talk about the case law that plaintiff's counsel has cited. LaFaro, I don't read LaFaro as saying that speech to a crowd isn't harassment because it's ephemeral. The holding in LaFaro was that when someone makes a comment to another person or a crowd of persons that the plaintiff simply happens to overhear, that is not directed at the plaintiff, and therefore it does not qualify as harassment. Now, the 3 cases that counsel cited in his briefing, the one presidential case and the two non-presidential ones. They all involve cases where the defendant actually did direct speech towards the victims in those cases. In the one presidential case, I apologize, I can't remember the name off the top of my head, but it involved two people who were divorced spouses who both had worked at APS. The ex-wife contacted the ex-husband's co-workers at APS, saying bad things about her ex-husband, urging them to contact her, urging them to knock some sense into him. That is obviously speech that is directed at that person because they were directly contacting people in his life, his coworkers. One of the non-presidential cases, I believe it was the Snyder case, the defendant in that case also directed social media statements about the victim to her coworkers, to her clients, to her former employer. That defendant actually recorded a video of himself outside of the victim's place of employment and sent it to her clients and former coworkers. Obviously, that's directed at the victim. That's not what Mr. Andrejev did here. In the Williams case, the other case that he cites, that was a case where a photographer apparently became obsessed with a model. In that case, the comments that the defendant in that case made were tagged directly to the victim. In other words, the defendant in that case sent his comments, some of them, directly to the victim. That's not what we have in this case. And, you know, Your Honor, the requirements that the speech be directed at the plaintiff and that it have no legitimate purpose, they serve the purpose of protecting First Amendment speech. The Supreme Court has been very clear that the First Amendment protects a robust and vibrant and sometimes difficult and emotionally hurtful national debate. But we have to give that breathing room for that kind of rollicking and at times unpleasant, at times vulgar kind of speech, so we can have the kind of robust and wide open national debate that the First Amendment is designed to protect. And that's what's at issue here, Your Honor. Going to the second element, Ms. Owens has not met her burden of proof to show that the speech would cause a reasonable person to feel harassed. Yes, he used vulgar language. Yes, he expressed the opinion that she's guilty and should go to prison. Yes, he expressed his view that she's misled multiple courts. But no reasonable person would consider that to be harassment. And as plaintiff's counsel said, in response to Mr. Andrejev's motion to quash, Ms. Owens went nuclear. Her response brief falsely accuses Mr. Andrejev of committing multiple felonies, including perjury and felony harassment. It's just not true, and it's not true based on what is the content of the reply brief, of the response brief itself. She accuses him of violating the injunction, likening it to one of those cases in which a defendant posted online a image of the protective order in that case that included the victim's address. Here, as Ms. Owens testified, what he posted online didn't include her address. The injunction did not prevent him from talking about the injunction. The injunction, despite what she may believe, did not prevent him from talking about Ms. Owens. And he didn't violate the injunction in any manner whatsoever. And she also accuses my client of perjury for what he said in his original declaration. And as you saw, Your Honor, What he said in his original declaration is absolutely 100% true. The statements she attributes to video 272 do not appear anywhere in the transcript of video 272. That's what he said in his declaration, and that is absolutely true. And it is, quite frankly, offensive that she would accuse him of perjury, of a crime, of deliberately lying to this court, when what he said was precisely, absolutely true. It is her burden of proof here. If she makes a mistake in her petition, she can certainly correct it. He made a mistake in his original declaration. He corrected it in candor to this court. He didn't have to, but he did, because he wanted to make sure that the court had the facts. In sum, Ms. Owens' petition is baseless. It's meant to try to shut up a critic who makes public statements about the issue of public concern being her court cases. And, Your Honor, we would ask that you award us our attorney's fees and take into account the false accusations against my client of felony conduct. Thank you.
Anything further?
In about two minutes or less. And Your Honor, thank you so much for giving us more time. I really appreciate it. Very, very briefly, couple legal things and a couple factual things. Legally, all the court has to do is read the Snyder and Williams and Raber cases I've cited in my pleadings. Those cases tell you everything you need to know about the law. Yes, two of them are unpublished, non-precedential. They're still you can still look at them and consider them and follow them if you want to. You cannot ignore Raber. It's a controlling published authority. Those cases involve conduct that is so much less worse than what we heard today. So much less. And let's talk briefly about what you heard today. What we heard was almost nothing about Ms. Owens' criminal case. Almost nothing. There was I didn't hear Mr. Andrejev say a word about what she's charged with or why there's some significance to that fact. He talked about her body. He talked about wanting to join the Mile High Club with her. He talked about her performing oral sex on prison guards and getting pregnant in prison. I didn't hear a matter of public concern insofar as they're arguing the criminal case is a matter of public concern. That's all correct. That's not what we're here to talk about. We curated these exhibits very carefully to not focus on First Amendment protected speech. If he wants to talk about her criminal case, great. Stop calling her a cunt and a whore and making statements that are inflammatory. And the reason, Your Honor, that I think you really should expand the order to say he is not allowed to attend any more court hearings. Ms. Owens has a right to sit in court not in fear. And if she was sitting on the witness stand today, she had to look at this man who she knows what he has said about her and how horrible of a person he has acted like. And she shouldn't have to deal with that in addition to everything else she's going through. He's posted pictures of her house, not within the last year, but I showed that as just a part of the intimidation that he has committed against her. And as far as this issue of me going too far with accusing him of perjury, Your Honor, you're the fact finder. You can read his declaration, the first one that he filed, and couple that with his pleading that he filed at the same time. His declaration said that he quoted these things that I'll fucking bitch slap her through the phone and she's a fucking twat, she's a hole, she's a cunt. And then he said that statement appears nowhere in that transcript or in any other live stream Owens cites for that matter. And then in his pleading, he says, contrary to Owens' mischaracterizations and outright fabrications of what Andrejev actually said. If I were you and I read those things, I would say, she must have lied. She lied. He never said these things. They're fabrications according to them in a sworn statement under penalty of perjury. He knew that he said those things. You heard him say those things. He didn't take the stand and deny that he said those things. Was there a typo on which thing they were? Yes, there was a typo, but he doesn't say that. He says that those statements do not appear in any other live stream she cites, and she cited them all. She brought to the court's attention that there were 1,400 of them. And I'm sorry that she made that typo, and I'm sorry that she didn't have time to go through every single video. But to me, when I read that, there was a clear intent to mislead the court about what was happening in the factual realm. That he tried to convince you that these things never happened, and they did. We just watched them all. So I think that's perjury. Whether you think it's perjury, that's your call. but that's certainly enough to warrant, first of all, upholding the order and expanding it and awarding us fees, because we shouldn't have had to come down here to do any of this. So that's all I have to say, unless you have questions.
I don't think I do have questions. All right, so like we discussed earlier, this was a lot of information to try to take in and to do quickly, and some of that I only received today, not due to anyone's fault, just the shortened time frame here. So I'm going to take this under advisement so that I can review the motion to quash, response, and reply, and then I will issue a ruling at that time. I will try to get it done today. So I don't in any way want to belabor this issue for you all. I just want to make sure that I have been able to thoroughly review everything that was submitted in writing in concert with the arguments that both sides have made here today. So having said that, do we have to distribute something immediately? So we can send it after. Okay. Okay. So having said all of that, is there anything else we need to discuss for today?
The only thing I would add, Your Honor, is in my effort to be a helpful counselor, is if, as you're preparing all this and researching, if you have any questions, if the court wants any kind of supplemental briefing on a legal issue or anything like that, please feel free to ask. I try to be helpful. So I don't want you to feel like there's a question you're not sure about or whatever.
Sure.
Yeah, and the same goes for.
Okay. All right. I have only been in this assignment since October, so I'm not shy about asking for briefing. I think I'm going to be okay on this one, but I will keep that in mind if I decide that's not the case, and I will let you all know so that you can address any concerns, okay?
Thank you, Your Honor.
All right. Thank you. We're adjourned. Have a good rest of your day. Good weekend.
Thank you.
And we will send it out by email. So I'll get it out to you all as soon as possible. Like I said, I'm hoping for today. Today's normally a day that I have opportunity to get paperwork done. So hopefully this can be one of those things.
Have a nice weekend.
Thank you.
To close this case, the court issued its final ruling. The judge denied the defendant's motion to quash the injunction against harassment, meaning the injunction remains in effect. The court also denied the plaintiff's request to bar the defendant entirely from attending court hearings. However, the judge ordered that if the defendant chooses to attend any of the plaintiff's court proceedings, he must remain at least 10 yards away from the plaintiff at all times. Finally, the order ruled that the plaintiff may submit documentation seeking reasonable attorney's fees and costs related to this matter. With that, the court issued and filed its final order, bringing this injunction case involving Laura Owens and Robert Andrejev to a close. Thank you so much for watching and for supporting our channel. It truly means more than you know. If you found this video helpful, please give it a like and make sure you're subscribed so you don't miss what's coming next. All the best!